adjustment of status after divorce. Is it possible? Under U.S. immigration law, when a foreign national enters the U.S. on a K-1 fiancé visa, he or she must marry the U.S. citizen fiancé, the petitioner, within 90 days of the arrival in the United States. After marriage, they have to file for adjustment of status. If the marriage is less than 2 years old at the time the adjustment is granted, the foreign national will be given conditional residency, valid for 2 years. At the end of the 2 years, the couple must file a joint petition to remove the conditions on the green card. But what happens if everything doesn't go as planned and the couple gets divorced while their adjustment application is pending, sometime before the green card is granted? I.e., the foreign national enters the U.S. on a K-1 visa, files for adjustment of status, but before the initial adjustment interview, the couple gets divorced. This issue recently came before the Ninth Circuit Court of Appeals. The decision by the Ninth Circuit Court of Appeals on K-1 adjustment of status after divorce. The facts of the case. Yelena Chon was admitted to the U.S. in 1998 as the fiancée of a U.S. citizen, and her 2 children were admitted as K-2 status. On February 20th, 1999, Yelena married her U.S. citizen fiancé, Albert Tapia, and on April 14th, she and her children applied for adjustment of status. Almost 2 years later, on April 9th, 2001, 5 days short of their second wedding anniversary, Chon and Tapia divorced. Yelena's immigration nightmares began on August 27, 2001, when the USCIS denied her adjustment of status application because of the divorce and placed her in removal proceedings. An immigration judge also denied her adjustment application, and the Board of Immigration Appeals agreed with the IJ. The BIA also denied Yelena's motion for reconsideration. What were the USCIS arguments? The USCIS based their decision on the fact that the marriage was no longer viable. It was argued by the USCIS that a K-1 visa holder is ineligible to adjust status to lawful permanent residence if the marriage ends before the USCIS adjudicates the application for his or her K-1 adjustment of status. What were the petitioner's arguments? Yelena challenged the BIA's ruling before the Ninth Circuit Court of Appeals. The principal issue was whether the immigration judge and the BIA had properly interpreted Section 245D of the Immigration and Nationality Act, which holds that the Attorney General may not adjust the status of a K visa except to that of an alien lawfully admitted to the United States on a conditional basis under Section 1186A of this title as a result of the marriage of the non-immigrant to the citizen who filed the K petition. The Court's opinion on August 12, 2008, in an important immigration decision, the Court held that the foreign nationals who marry their fiancé after entering the United States on a K-1 fiancé visa and who subsequently obtain a divorce prior to obtaining permanent resident status are still entitled to adjust to resident status. The Appeals Court held that it found nothing in the plain language of 245D suggesting that an application that was valid when submitted should be automatically invalid when the petitioner's marriage ends in divorce 2 years later. The Court also held that the purpose and context of Section 245D also do not support the government's reading of the statute that requires the automatic removal of immigrants whose marriages end in divorce while their application for adjustment of status languishes in the agency's file cabinet. The Court relied on their previous holding in Freeman v. Gonzalez, 444 F. 3rd and 1031, and as a result of the Court's decision in Chon and Kasi, Yelena's immigration nightmare finally ended. The holding continues a long line of cases, including Matter of Boramont, Matter of McKee, that hold that a marriage must only be valid at inception. Indeed, the parties do not need to be married at the time USCIS adjudicates the application for adjustment. Freeman v. Gonzalez. In Freeman v. Gonzalez, again, 444 F. 3rd, 1031, Ninth Circuit case from 2006, it was held that if a marriage to a U.S. citizen was bona fide, the fact that the citizen's spouse dies before the USCIS makes a final decision on the application for adjustment of status does not stop it from being approved. In conclusion, the government has long refused to grant adjustment of status for K visa recipients whose good faith marriage ended in a divorce prior to the adjudication of the adjustment application. It is gratifying to see that the termination of the good faith marriage through divorce need not result in the removal of the K visa holder when it is the government that takes several years to adjudicate the applications. Prior to the Chone decision, the USCIS would have denied the application for K-1 adjustment of status after divorce, since the marriage was no longer in existence. However, this is no longer true, at least for applications submitted by persons who live in any of the states within the jurisdiction of the U.S. Court of Appeals for the Ninth Circuit. Those include Alaska, Arizona, California, Hawaii, Montana, Oregon, and Washington. Thus, if you enter into a bona fide marriage, but unfortunately the U.S. citizen's spouse dies, or the marriage ends in divorce before the USCIS makes a decision on the application for K-1 adjustment of status, don't panic. The Ninth Circuit's holdings in Freeman v. Gonzalez and Chone v. Mukasey may still save you from deportation and allow you to adjust your status to permanent residence. If you have any questions about what steps you should take in your particular situation, consult a Visa Pro immigration attorney. We will be happy to guide you through the process.